Maybe, in respect of item number 5, madam,
Item number?
5, madam,
Yes.
I seek some accommodation for today, madam. Can it come up next week, madam?
Okay. On the prayer of Mr. Andreas, learned legal aid counsel for the appellant. List the case in the next week. MS P. Bhuya, learned senior counsel and additional public prosecutor. For the respondent state is present and has no objection to the said prayer.
I'm obliged.
May I please, Your Lordship? Lordship, similar prayer in respect of item number 10, Your Lordship.
10.
Any date in next week, Your Lordship.
On the prayer of Mr.
Arbor.
Arbor, learned counsel, have you informed the other side?
I have contacted him. Lordship,
Then
he told me that
you have to
no, he told me that brief has been already taken from him. He is no longer appearing in this case, Your Lordship.
Mr. B. Sharma, I don't know. No, then sometimes they come and say that no function has been taken.
No, Lordship, I
As
have,
if the court has granted.
today morning on itself, I have talked to him, Your Lordship. Any date next week, Your Lordship.
Prayer of Mr. Arbor, learned counsel for the appellant. The case stands adjourned for a week. It is submitted that the learned counsel for the respondent has been duly informed.
Obliged, Your Lordship.
May I please, Your Lordship? Lordship, with the consent of the other party, I beg to mention item number 6 and 7 of today's list. Lordship, kindly adjourn this matter for today only.
Your
I am appearing on behalf of SK Nargis, Lordship.
name,
K. Borpujari.
MSK Borbujari. Learned counsel appearing for MSSK Nargis. Learned counsel for the appellants in both the appeals. As prayed for adjournment of the appeals for 2 weeks. You have informed the,
Lordship.
it is submitted that consent has been taken from the learned standing counsel, learned public prosecutor, on learned standing counsel customs and NCB to make the prayer. First of all, the prayer is allowed, leaves the appeals after 2 weeks or in 2 weeks by the office.
For hearing, item number 17.
PW1, Srimati Yapi Horo was the wife of the deceased and is the sister-in-law of the accused. As regards the incident, PW1 deposed to the effect that at about 2-3 p.m. on the date of the incident, she was at home after getting her health. She was at home cooking food, after returning from a health checkup. Full stop. At that time, she was told by her husband that she would eat meat. Full stop. In reply, she told her husband that she would bring meat if she did not get fish. Full stop. At that time, the accused came to their house and assaulted her. Full stop. Then a trial, then a scuffle ensued between her husband and the accused. Full stop. According to PW1, she tried to dissuade them. Full stop. But the accused picked up an axe in his hands. As the axe was kept outside. Full stop. Then, the accused came inside the house and assaulted her husband to death by striking with the axe. Full stop. PW1 further deposed that the accused also told her that she would be killed after coming out after 3 months, when the accused would come out of jail. Full stop. PW1 stated that her husband was killed in the kitchen itself. Full stop. As a result of the blow on his head, comma, her husband's head got cracked. Full stop. The accused then went to the police station. Full stop. It was at about 8 p.m. The police personnel came to the place of occurrence and took away the dead body of the deceased as well as the axe. Full stop. She identified the axe in the court and stated that when the seizure list was prepared, she gave her thumb impression there. Full stop. She is stated to have handed over the axe to the police. Full stop. The FIR, according to the PW1, further stated that it was in the morning on the next day, the FIR was lost by her at the police station. Full stop. She affirmed that the FIR was written as per her words, wherein she put her thumb impression. Full stop. She further stated that in the inquest report prepared by police on the date of lodging the FIR, she put her thumb impression therein also. Stop there. In the cross-examination, PW1 stated that there was no enmity between her husband and the accused, though the two families did not have visiting terms. Full stop. As regards the incident, PW1 further stated that at that time, at the relevant time, she was cooking food after coming back from the hospital. So then her husband came and assaulted her in anger for not cooking meat. Full stop. When her husband was assaulting her, she cried loudly. Full stop. Hearing her cry, according to PW1, hearing her crying, two persons named Sunil and Rajan, not witnesses.
No, my lord.
Within bracket, করবো?
Rajan is there. His Rajan Horo is there.
PW5.
Whether he's the same person, of course, we don't know. PW5 is there. Rajan Horo.
Sunil লিখিব, not a witness.
Sunil Haro, asset PW10. I think PW Lordship.
Suresh, I think.
Suresh Nike. Oh, yeah.
He's not
I'm
Sunil.
sorry.
He's not Sunil.
Not a witness. And Rajan came there. Full stop. At that time, the accused, whose house was adjacent to the house of the informant and the deceased, came there, crossing the concrete boundary wall between the two campus. Full stop. At that time, the PW1 stated that at that time also she was crying. See, PW1 denied suggestions. That she did not state before the police that the accused had assaulted her, semicolon, that the acts she saw in the court. No. And suggestion. So, PW1 further denied that denied suggestions that it was her husband who picked up the axe. And when all three of them tried to snatch the axe, her husband got injured in the process. So, she also denied the suggestion that the accused did not threat her of killing. Suggestions, and that she had enmity with the accused, for which she gave a false, she deposed to implicate the accused. Para. PW2, Chowni Horo was the mother of the deceased and is the mother of the accused. No. The deceased was the elder son, and the accused is the younger son of PW2, Chowni Horo. PW2 deposed that on the date of the incident, she returned home only at around 5 p.m. At that time, the dead body of her elder son, that is, the deceased, was lying on the veranda. Nancy came to know that he died in a fight between the two brothers. She deposed to the effect that it was the deceased who came to kill the accused, and then, the accused killed his elder brother. Then, the accused went to the police station. Later on, when at around 6/7 p.m., police personnel came from the police station, they took away the axe from the house of the deceased. She stated that the axe shown to her was the axe which was picked up, which was taken away by the police person. She further stated that she also went to the police station and put her thumb impression in the inquest report prepared at the police station. In her cross-examination, PW2 admitted that she did not see the incident. একদম প্রথমতে লিখক who is the so and so লিখিছে বা younger son আৰু elder son. PW2 used to reside with the accused. Para. PW 3 is a resident of the same village. No, was the village of Rongajan village. Commander village where the accused and the deceased were in evidence. Post PW3, in his testimony, stated that during the evening hours on the date of the incident, he was at his home. And at that time, one Bango Horo, within brackets. Bango Horo is not a witness.
No.
Bango Horo, within bracket, not a witness. Inform him that the accused had killed his elder brother, Kustum. On receiving the information, he immediately informed he telephonically informed after telephonically informed the police station, went to the place of occurrence, that is the courtyard of the accused. Going there, he saw the deceased lying on the veranda of the house. So he saw one injury on the head of the deceased, one bleeding injury on the head of the deceased. At that time, PW1 showing him the axe, told him that her husband was killed with that axe. PW3 stated that he was at the place of occurrence when the police personnel came and seized the axe wide seizure list by the seizure list, EXT1, wherein he gave his signature as EXT11. PW3 stated that the axe which was produced before the court PW3 recognized the axe which was shown to him as MAT EXT1. He further deposed that the accused appeared in the police station on the date of the incident itself. Sapera, in his cross-examination, PW3 stated that he did not witness the incident of assault. While he was at home, he was informed that he denied suggestions that he did not inform the police and that there was an injury wherefrom there was an injury on the head of the disease wherefrom blood was oozing out. Full stop. He further stated that the X within bracket met EXT1, which was shown to him in the court, was the same X which PW1 showed to him earlier. First of all, PW4, Deepta Kanta Bora was serving as Subdivisional Medical and Health Officer. What ছিল এটা? SH Civil Hospital, Tejpur on Connaught Civil Hospital, Tejpur on 24/4/2014. Pustak. It was on 24/4/2014, he performed the postmortem examination on the dead body of the deceased in reference to Borghat Outpost General Diary entry number 360 dated 23/04/2014. PW4 deposed that on examination of the dead body, he found he reported the following in the postmortem examination report. 56. Page 70, no? Red mark or brown? Red mark. PW4 further deposed that 17/18 red mark to red mark. In the postmortem examination within bracket PME report, he opined that the deceased died due to the head injury. PW4 exhibited the PME report as EXT1, which is signature therein as EXT21, and the signature of the Joint Director of Health and Medical and Health Services, Sunit Potechur, as EXT22. Pushta. Para. Supper. When defense cross-examined PW4, PW4 stated that in the PME report, he inadvertently wrote the date as 24/4/2012 instead of 24/4/2014. So He further clarified that in the PME report, he wrote the date as 24/4/2014 under his signature. Full stop. As regards the injury, PW4 stated that the injury might also be caused by fall on hard substance. Full stop. Para. Son. PW5, the testimony of PW5 was not relevant as he testified that he was not as on the date of the incident, he was at another place in connection with a marriage ceremony. Full stop. As per PW7, he returned PW7, a co-villager, he returned from his duty at about 6:30 p.m. on the date of the incident. And on his return, he was informed about the incident that the accused had killed his elder brother. Full stop. In his cross-examination, PW7 admitted that he did not see the occurrence himself. Full stop. He had, however, stated that the deceased and the informant, stating that his house situated near the house of the informant, PW1, and the deceased, PW7, stated that the informant PW1 and the deceased usually used to enter into altercation and tussle. And they also used to enter into assault. There, on a previous occasion, the informant had assaulted the deceased by means of a lathi. Well, PW8, another co-villager, testified to the effect that at the time of the incident, he was at another place, full stop, and he returned doing duties, and he returned from his duties at about 6 p.m. full stop. After his return, his wife informed him that the accused had killed his brother by means of an axe. Full stop. When police personnel came and asked him to show the house of the deceased, he showed the house of the deceased. Full stop. In his cross-examination, PW 8 stated that he had not seen the occurrence himself and did not know how the disease was killed. Full stop. As regards past relation, PW 8 deposed that the informant PW 1 within bracket and the accused used to enter into altercation and tussle. A co-villager and a neighbor video. He denied the suggestion that it was the informant who had killed her husband. Full stop. The testimony of PW 9 is not of much relevance as he deposed that he did not know how the disease has died, and the police had not recorded his statement from Gabon. Full stop. The testimonies of PW 9 and PW 10. PW 6, Mangra Horo, new. The deceased as well as the accused full stop. On the date of the incident, he deposed that on the date of the incident, he was not at his home. Full stop. While he was returning home, his uncle, Robert Horo, informed him that the accused had killed his elder brother. Full stop. Then, oh, his brother or what? His brother.
Yes,
Okay.
PW 6,
6 1.
Okay.
brother.
Sorry, PW 6 negligible. Was a brother? Was PW 6, Mangra Horo, the disease and the accused were brothers. Full stop. PW 6 deposed that on the date of the incident, he was not at his house. Full stop. When he was returning home, his uncle, Robert Horo, informed him that his brother, the accused, had killed their elder brother, the deceased. So then he, on reaching his house, he saw his elder brother lying in the courtyard. So then he called the people of the vicinity. So it was at about 6 p.m. The time was about 6 p.m. Post up. On his call, some of the villagers came to the place of occurrence, and Gangura informed the incident to the police station. In his cross-examination, he denied a suggestion that the informant and the deceased used to have quarrels. Post up. As he did not see the occurrence himself, he stated that he did not know who had killed his elder brother. Full stop. Fair enough. The IO of the case was examined as PW 11. Post up. In his examination in chief, PW was 11 stated that on 23/4/2014, he was serving as in charge, Borghat Police Outpost, full stop. At around 6 p.m. on that day, the accused appeared before the Borghat Police Outpost and informed that he had killed his brother, Matho Horo, by assaulting with an axe. Full stop. As he surrendered, the accused had thus surrendered at the police station. Full stop. In respect of, in connection with such act of surrender, he registered a general diary entry number 360 dated 23/4/2014 and took the accused into custody. Full stop. After informing his superior officials, PW 11 stated to have proceeded for the place of occurrence at village Rongajan Midigaon, where the house of the accused situate. Full stop. On reaching the place of occurrence, he noticed the body of the deceased, dead body of the deceased lying on the veranda of the house of the accused. Itu ketika itu, body itu, ya gua muncul, video kok muncul. Few says the body was in a courtyard, few says veranda.
And it said that the incident took place in the kitchen.
Maybe PW1 was in a state of shock, and mother stays with the accused, so body was taken.
2:03 PM as per PW1. Then PW2 returned home at 5 PM. That time she saw the dead body was lying on the veranda. And PW11, he also reaches at 6 PM, my lord. Oh, he appeared at 6 PM, the accused person. And that time he saw that he was lying in the veranda.
After reaching the place of occurrence, the inquest was not conducted at that time. First of, instead, he visited the vicinity of the place of occurrence and recorded statements of few witnesses. Full stop. The wife of the deceased, PW1 produced an axe to him and informed him that it was by the said axe, the accused had committed the crime. Full stop. The axe was seized by the seizure list, EXT1 in presence of witnesses. Full stop. Ayo further stated that he prepared a sketch map of the place of occurrence while EXT3 full stop. Thereafter, the dead body of the deceased was taken to Konaklata Civil Hospital, Tejpur. Full stop. It was on the following day, the inquest on the dead body of the deceased was done white was done and thereafter white EXT 4 inquest report. Also, PW11 further stated that during the inquest, he noticed one injury towards the back left side of the head of the deceased and there was blood coming out of the nose and mouth of the dead body. He exhibited the FIR as EXT5 and the charge sheet, the charge sheet as EXT6 and the X seized by EXT1 seizure list as MET exhibit 1. So he stated that he seized the X from the wife of the deceased. In his cross-examination, the IO of the case PW11 stated that though the incident had occurred on 23/4/2014, the FI was received on 24/4/2014. Full stop. It was on 23/4/2014, the accused surrendered before the police at the police outpost. And on such surrender, the accused was taken into custody by him. Full stop. Custody by him, and till his father, till his arrest, the accused was in the custody. Full stop. He further stated that before proceeding to the place of occurrence, he registered a general diary entry number 360 on 23/04/2014. Full stop. PW11 further stated that he did not send the seized X for FSL examination, and he did not notice any blood stain on the seized X. Full stop. He further stated that when he reached the place of occurrence, he found the wife and the mother of the deceased there. He denied to have conducted the investigation not in a proper manner. Full stop. He denied all other suggestions put to him by the defense. Full stop. Para. The defense, the sole defense witness, DW1, Kudra Gore, deposed that he knew the informant as well as the accused. Full stop. He stated that he was a resident of the same village. Full stop. It deposed to the fact that on the date of the occurrence, he, along with the accused, went to catch fish in a nearby river. And it was at that time, they heard that an assault had taken place in the village. Full stop. Having heard about the assault, fight, marpit mane fight. Having heard about the fight, they came back to the village and went to the house of the deceased, where from the wherein the commotion arose. Full stop. Going there, comma, they found the disease lying in the veranda, no, on the veranda. On the veranda. And he heard from the people assembled there that the deceased had a quarrel with his wife. Comma, that is the informant, PW1. Full stop. Software. When DW was cross-examined, comma, he stated that he had come to court to give evidence along with the accused. He just something meaning he is not a fact that the accused went with me to catch fish. He admitted. He further
Oh.
admitted a suggestion that he further stated that he denied a fact. No, it is not a fact. So the accused went with me. By denying a suggestion that the accused went with him to catch fish. This witness appeared to have impliedly admitted that the accused was not with him catching fish on the date of the incident. He denied a suggestion that the accused had dealt the blow on the head of the deceased with an axe on the date of the incident and caused his death. Yeah. On going through the testimonies of all the witnesses, it has emerged that the house of the accused and the house of the deceased were situated adjacent to each other. Most of the deceased used to stay with his wife, that is the informant within bracket PW1, whereas the accused used to stay in his house with his mother, PW2. Most of जो boundary ऐसे नहीं from the dope by adducing a defense witness, DW1, the accused had taken a plea of alibi that on the date of the incident and at the time of the at the time and date of the incident, he was not present. Full stop. The learned trial court had rightly discarded the the learned trial court had considered the evidence of DW1 and the plea of alibi taken by the accused. Full stop. Upon consideration, the learned trial court discarded the testimony of DW1 finding that the same was unworthy of credence and the same could not be accepted as true. Full stop. One of the reasons for discarding the evidence of DW1 was that no suggestion was made to any of the prosecution witnesses when they were examined. That at the time of the alleged occurrence, the accused was catching fish and his presence at the place of occurrence was not at all possible. Full stop. The further reason, or no, another reason for discarding the plea of alibi was that the accused, during his cross-examination under Section 313 CRPC, also did not mention anything as regards his presence elsewhere at the time and place of occurrence. Full stop. Furthermore, the presence of the accused at the time and place of occurrence was found to be established from the evidence of the prosecution. Full stop. The evidence of the IO, PW11 also established that the accused had surrendered before the police at Borghat Police Outpost at 6 p.m. on 23/4/2014. Full stop. We have found no reason to disagree with the reasons given by the learned trial court. তাতে কন্টিনিউ এইটো নালাগে we are in disagreement নালাগে এটা judgment আছিল যে yesterday you were given judgment regarding plea of LEB M. Burma.
Oh.
হেৰি এটা হেৰি অনন্ত এটা yesterday.
নামটো কি আছিল? তো মনত নাই নহয়, যোৱাকালি দিছিল। যোৱাকালি প্ৰিণ্ট ওলাই দিছিল। নেট নাই ন?
A plea of alibi has to be proved with absolute certainty so as to exclude the possibility of the presence of the accused at the place of occurrence at the relevant time. Full stop. When a plea of alibi is raised by an accused, it is for the accused to establish the said plea by positive evidence. Full stop. The accused did not enter into the witness box himself to adduce evidence in support of his plea of alibi. Full stop. The defense witness, DW1, had merely mentioned that on the date of the occurrence, he was with the accused catching fish in a nearby river. Full stop. But DW1 did not mention anything about the time when they were catching fish. Full stop. There was thus, no certainty found as regards the time period of the accused being present elsewhere other than the place of occurrence other than at the place of occurrence at the relevant time. Full stop. For the reasons cited by the trial court, as well as the failure on the part of the accused to lead positive evidence with absolute certainty so as to completely exclude the possibility of the presence of the accused at the time and place of occurrence, the plea of alibi taken by the accused in this case is found not acceptable at all. Full stop. It is settled that even though the plea of alibi of the accused is not established, it is still the duty of the prosecution to prove the case against the accused. Full stop. Para. Amongst the prosecution witnesses, it was only the informant written by PW1, who was the wife of the deceased, who was found to be the only eyewitness. Full stop. It is well settled that an order of conviction can be based on the sole testimony of an eyewitness, provided such testimony is found to be trustworthy, inspiring confidence, minor inconsistencies, leaving aside minor and trivial inconsistencies. Also, during the examination of the prosecution witnesses, the accused was not found to have taken any defense. As discussed above, the accused was found to have not taken any defense, that he was not present at the time and place of occurrence, that is at the place of occurrence, that is the house of the informant and the deceased. Full stop. para. On the informant, informant PW1 on a combined reading of on a reading of the entire testimony of the informant, PW1, it it emerges that on the date of the incident, she went for a health checkup at the hospital, at a hospital. Full stop. After coming back from the hospital, she was cooking food. Full stop. At that time, her husband came and assaulted. Oh no, full stop. Informant was told by her husband that he would eat meat on that day. Full stop. The informant stated to have replied to her husband that if she did not get fish, then only she would bring meat. Full stop. While the informant was cooking, her husband came there and assaulted her in anger for not cooking meat. Full stop. On being so assaulted by her husband, the informant cried loudly. Full stop. The informant stated that hearing her cry, two persons named Sunil and Rajen came there. Full stop. The prosecution he doesn't হয় জানো PW5 please এইটো হয় জানো ই হয় জানো maybe came. At that time, the accused who used to reside in the adjacent house came to their house, crossing the concrete wall standing between the two houses. Full stop. it was, but, according to PW1, she was crying at that time also. Yes. Coming to the house, the accused, according to the informant, assaulted her and full stop. Thereafter, a scuffle ensued between her husband and the accused. Full stop. She made efforts to dissuade them. Full stop. It was at that point of time the accused picked up an axe in his hands. Full stop. The axe was picked up by the accused from outside the house. Full stop. In the FIR EXT1, the informant PW1 mentioned that the axe was kept in the courtyard by her husband after cutting firewood. Full stop. After picking up the axe, it does appears, it does, transpires that after picking up the axe from the courtyard, the accused came inside the house and gave and assaulted her husband by striking with the axe. Full stop. The assault was made on the head of Mato Haru. No, I'm sorry. No, PW1 further testified that the accused assaulted her husband on his head, and as a result, his head got cracked. Full stop. PW1 further testified that the assault by the accused on her husband was made in the kitchen of the house. Full stop. When the above testimony of the informant, PW1 is tested is analyzed with the testimony of the autopsy doctor, PW4, the inquest report EXT so and so, and the PME report EXT so and so, a consistency is found to the fact that the কোনখিনি মাৰিলে? The skull, there is injury. Consistency is found. First of, as per the PME report, EXT so and so. Left parietal and temporal bone in the skull were broken to several pieces, and there was a torn over the temporo-occipital region on the left side. PME report আছে এটা wordবোৰ, huh? First of, the left side of the brain was broken under the broken skull with free blood. First of, as per the PME report, EXT so and so, it was the head injury which resulted into the death of the deceased. Full stop. The inquest report EXT so and so is found to be consistent with the PME report EXT so and so, as in the inquest report EXT so and so. It was recorded that there was an injury on the backside of the head of the deceased. Full stop. From the evidence on record, it has further emerged that the death of the disease was instantaneous. Instantaneous. Full stop. Thus, there is no manner of doubt that on the date of the incident, there was a scuffle between the accused and the deceased, and it was in the process of the said scuffle, the accused picked up an axe and struck at the head of the deceased with the said axe. Full stop. Prosecution witnesses, comma, PW one. PW two. PW two. PW two, no, PW three. And PW 11 was shown annex comma met ext1 seized by Caesar list ext so and so during the course of their depositions, comma, those witnesses deposed to the fact that they had recognized the X as the one which was seized during the time of investigation. Post hoc. The accused. There was those witnesses, prosecution witnesses, were not questioned by the defense on the in respect of the said acts. Post hoc. Post hoc. তার পিছতে আগৰ যে আছিল যে এমাৰ্জ কৰি picked up 10 next এই পাৰ্টটো এইখিনিতে সোমাইছে হৈ গ'ল পুস্তক does we are of the considered view or no, we are of the unhesitant that it was the act of the accused. It was due to the act of assault of the accused, comma, the deceased had met instantaneous date. Full stop. We'll come back. We'll decide culpable homicide or not amount. 302 or 304. As regards the contention of the learned amicus curiae, that there were certain inconsistencies in the versions of the informant, PW1. কি করলো? Comma, it is found that the informant, PW1, in the affair had reported that after trespassing into the house, the accused tried to assault her. Full stop. In the version given before the court, the informant, P21, had improved from our earlier version slightly, to an extent that in her testimony, in her evidence in chief, she stated that after coming to the house, the accused assaulted her. Full stop. Uh, there is nothing in the evidence that the because of either the attempt to assault or assault, the informant PW1 had sustained any injury on her person. Full stop. In our considered view, such inconsistency does not make the testimony of the informant PW1 as unreliable as the informant PW1 was consistent on the material points as regards the assault made upon the deceased by the ex. Full stop. When an act of assault by a weapon results in a homicide till date of a person, a question which always arises as to whether the death was an act of murder or an act of culpable homicide not amounting to murder. Somebody said to some. Said to say IPC kon sound. What are the said to আসলে যে said to আসলে mark করা এইটো নহয় নহয় আচ্ছা প্ৰিন্ট আউট টো যে Section 299 of the Penal Code has defined culpable homicide and Section 300 IPC has described the kinds of culpable homicide which are murder. As per Section 299, IPC, লিখি দিব। If The if an act of culpable homicide comes within any of the four clauses mentioned in section 300 IPC, then such culpable homicide is murder. Full stop. In the scheme of IPC, culpable homicide is the genus and murder its species. Full stop, meaning thereby, all murder is culpable homicide, but all culpable homicides, all murders are culpable homicides, but all murders are not culpable homicides. Full stop. Culpable homicide without the special characteristics of murder is culpable homicide not amounting to murder. Full stop. Para. In 2012, 13 SSC, 2012, 13 SSC 663. Full stop. Para. In Budhi Singh versus State of Himachal Pradesh, reported in 2012, 13 SSC 663. The Honorable Supreme Court has explained the manner or explain in what manner the court has to proceed if the court, whenever a court is confronted with the question whether the offense is murder or culpable homicide not amounting to murder, full stop, on the full stop. It has been observed that it will be convenient for the court to approach the problem in 3 stages. Full stop. A question to be considered at the first stage would be, whether the accused has done an act by doing which he has caused the death of another. Full stop. Proof of such causal connection between the act and the date, leads to the second stage for considering whether that act of the accused amounts to quote unquote culpable homicide as defined in section 299. Full stop. If the answer to this question is prima facie found to be found in the affirmative, the stage for considering the operation of section 300 of the penal code, is reached. Full stop. This is the stage at which the court should determine whether the facts proved by the prosecution bring the case within the ambit of any of the four clauses of the definition of quote unquote murder contained in section 300. Full stop. If the answer to this question is in the negative, the offense would be quote unquote culpable homicide not amounting to murder, unquote, punishable under the first or the second part of section 304, depending, respectively, on whether the second or the third clause of section 299 is applicable. Full stop. If this question is found in the positive, but the case comes within any of the exceptions enumerated in section 300, the offense would still be culpable homicide not amounting to murder, punishable under the first part of section 304 of the penal code. Full stop. Para. In the OFT quoted decision of the Honorable Supreme Court in Virsa Singh versus State of Punjab, reported in
Yeah, 1950.
1958, SC 465, clause 3 of section 300 IPC prescribes that if the act is done with the intention of causing bodily injury to any person, and the bodily injury intended to be inflicted is sufficient in the ordinary course of nature to cause death, then the act would amount to murder. তাৰপিছত এইটো লিখিব। Justice Vivian Bose, J. explain the meaning and scope of clause 3 of section 300 IPC, which has attained the status of locus classicus. The ingredients of clause quote unquote thirdly ফাৰুক বুলি মই দেখিছিলো যে Farooq boli. हाँ. Of section 300 IPC have been brought out as under. ইয়াতে Q to Q, huh? The court has further explained the third ingredient in the following word, R to R. বুদ্ধি সিং নহয় বুদ্ধি সিং নহয় হা বুদ্ধি সিং নহয় বুদ্ধি সিং নহয় uh, 15 state of Andhra Pradesh versus Rayavarapu Punaiya. Reported in 1976 for SSC 382. Uh, Having regard to the evidence stroke materials on record available, sorry, evidence emerging in the case in hand, comma, it is necessary to refer. It is apt to refer, apt, APT, to refer to the fourth exception of section 300 IPC, which covers acts done in a sudden fight. Full stop. In Dhiraj Bhai, Gorak Bhai, Nayak versus State of Gujarat, comma, reported in 2003, 9 SSC 322, comma, the applicability of action, exception 4 of section 300 IPC has been discussed. Full stop. It has been observed there that while in the case of exception 1, there is total deprivation of self-control, comma, in case of exception 4, comma, there is only that heat of passion, PASSION, which clouds man's sober region and urges them to deeds which they would not otherwise do. Though there is an element of provocation in exception 4, as in exception 1, comma, but the injury done is not the direct consequence of that provocation. Full stop. Exception 4 deals with cases in which notwithstanding that a blow may have been struck, or in whatever way the quarrel may have originated, comma, yet the subsequent conduct a sudden fight implies full stop. The help of exception 4 can be invoked if death is caused A, without premeditation, comma, B, in a sudden fight, comma, C, without the offender having taken undue advantage or acted in a cruel or unusual manner, comma, and D, the fight must have been with the person killed. Full stop. To bring a case within exception 4, all the ingredients mentioned in it must be found. Full stop. It has explained that the quote unquote fight occurring in exception 4 to section 300, comma, IPC is not defined in IPC. Full stop. It takes two TWO, two, to make a fight. Full stop. heat of patient requires that there must be no time for the patients to cool down. A fight is a combat between two or more persons, whether with or without weapon. It is not possible to enunciate any general rule as to what shall be called to be a sudden quarrel. It is a question of fact, and whether the quarrel is sudden or not must necessarily depend upon the proved fact of each case. For the application of exception 4, it is not sufficient to show that there was a sudden quarrel and there was no premeditation to stop. It must further be shown that the offender has not taken undue advantage or acted in a cruel manner. Full stop. The expression, quote unquote, undue advantage as used in the provision means, quote unquote, unfair advantage. Para. The intention to cause death or to cause an injury to cause such bodily injury as is likely to cause death can be gathered generally from a combination of following among other circumstances. Roman 1, the nature of the weapon used. Roman 2, whether the weapon was carried by the accused or was picked up from the spot. Roman 3, whether the blow is aimed at a vital part of the body. 4, the amount of force employed in causing injury. 5, whether the act was done in the course of sudden quarrel or sudden fight or free-for-all fight. Roman 6, whether the incident occurs by chance or whether there was any premeditation. Roman 7, whether there was any prior enmity or whether the disease was a stranger. Roman 8, whether there was any grave and sudden provocation, and if so, the cause for such provocation. Roman 9, whether it was in the heat of passion. 10, whether the person inflicted the injury has taken undue advantage or has acted in a cruel and unusual manner. Roman 11, whether the accused dealt a single blow or several blows. Coming back, reverting back to the facts of the case in hand, it has emerged from the evidence on record that there was a quarrel at the relevant time, there was a quarrel going on between the deceased and his wife, that is the informant, PW1. Full stop. In the process of such quarrel, The informant was assaulted by the deceased. Full stop. Though there was mention of two persons coming to the place of occurrence, comma, there was no other corroborative evidence to that effect. Full stop. It was at that point of time, that is, comma, when the scalpel, no, I'm sorry, full stop, the assault on the assault as a result of the sorry, due to such assault, comma, the informant started crying. Full stop. It was at that point of time, comma, the accused, who was in the adjacent house, comma, crossed the wall standing between the two premises. Full stop. It was only thereafter, comma, the accused involved in an altercation with the deceased, comma, who was the elder brother of the accused. Full stop. As per the version of the informant herself, comma, there was no kind of prior enmity between the accused and the deceased. Full stop. It was during the course of such altercation and scuffle, comma, the accused picked up an axe which was lying in the courtyard of the house belonging to the deceased and the informant. Full stop. After picking up the axe from the courtyard, comma, the accused came inside the house and gave the blow on the head of the deceased, comma, which resulted into his death. Full stop. Does, comma, when the accused came to the scene, does it appears that the accused came to the house of the informant of disease, hearing cry of the informant, and the purpose was to intervene in the in the intervene in the process of scuffle or altercation going on between the informant and the disease. Full stop. When the accused came to the place of occurrence, comma, he came unarmed. Full stop. When, due to his intervention, comma, a scuffle ensued between the accused and the deceased, it was then the accused picked up the axe which was already lying in the courtyard and gave the blow. In the course of a sudden fight, in the heat of passion, upon a sudden quarrel. Full stop. The medical evidence clearly indicates that there was a single blow by the accused কি করলো লাইনটো? There was only a single blow by the accused and single blow by the accused on the head of the deceased. Full stop. After giving the blow with the axe, comma, the accused did not struck any further blow on the deceased. Full stop. It thus shows that the accused had not taken any kind of, had not acted in a cruel manner. In a cruel or unusual manner. Full stop. However, the The injury was such. The injury caused by the X, inflicted by the X on the head of the disease was such that from the injury. uh, it was clear that the accused had the knowledge that the injury caused by him the bodily injury in, inflicted by him was sufficient in the ordinary course of nature to cause death. Errors. Subsequently develop হয়েছে এটা কি বুলি কয় ইনসুলিন নাছিলে ইনসুলিন নাছিলে Para. Though there might not be any intention on the part of the accused to commit an offense when he entered into stroke upon the property of the diseased, comma, by his act of assault on the disease subsequently. Has made his act made the act as one of criminal trespass. He was found guilty, right? MS act of criminal trespass. Full stop. Para. Uh, from the above discussion, comma, and for the regions assigned here, from the discussion made and the regions assigned here in comma, we have already found that it is a case which comes within the ambit of exception 4 of section 300 IPC. Therefore, comma, as the accused had caused such bodily injury to the disease, comma, which led to his instantaneous death, comma, is guilty of the offense of culpable homicide not amounting to murder under section 304, comma, part 1 IPC. Full stop. Thus, comma, the conviction of the accused under section 302, comma, IPC is not found sustainable in law, full stop. Having held the accused guilty of the offense under section 304, part 1 IPC, comma, we, after taking into account the facts and circumstances in entirety, comma, sorry. No, no, no. You have to come. To come. You have to call. During the 313, 313, including the age of the, I'm sorry, I'm taking, including the fact that the accused was of about 2019 or কিমান আছে 19 21 তেন্তে ঘটনাটো কেতিয়া হৈছিল was he a juvenile
Lordship, he was 21 years on 8/5/2019.
19 and the incident happened 14 years
She,
nobody has raised all these issues nobody has pointed out
Sorry, man.
we have hired you amicus
Sorry,
and public prosecutor
see my lord.
nobody has pointed out
23rd for 2014.
after
21 years.
the at the time of committing the offense, comma,
Hmm?
the
14.
accused was but the accused was of young age, having no criminal antecedents. Prior. At the time of committing the offense, the accused was a youth having no criminal antecedent. Full stop. We, after taking into account all the facts and circumstances in entirety, have found that a sentence of 8 years of rigorous imprisonment will subserve the ends of justice, without any alteration as regards the amount of fine to be paid. How much was fine? Be paid by him,
5,000, my lord.
in terms of the order, learned trial court. Full stop. Therefore, the sentence of the accused appellant stands altered from rigorous imprisonment ki side over for life to rigorous imprisonment for 8 years. Full stop. The instant criminal appeal stands party allowed to the extent indicated. Full stop. Any compensation? Any compensation
Lordship,
awarded or not
57-year under.
to
I don't think,
the
my lord.
informant?
No, my lord.
It's not reflected.
19 October to আসলে নাকি?
Whether the scheme was framed at that point of time in the year 2014,
Oh.
victim compensation scheme.
এইটো 14-12 ৰ পৰা আছে।
It was a 2010 maybe.
উম,
Folder. Folder condition.
Period already undergone has to be adjusted accordingly.
it is observed that the period already undergone by the accused appellant is to be set off for the is to be set off as per section 428, no? 428 here. Report over side, report outside. Post up.
এইটো 12 চনৰ পৰা আছে এইটো এটা অবজাৰভেশন
Oh.
দি দিলে হ'ল।
Para.
Service authority.
The jurisdictional district legal services authority will consider the matter of awarding appropriate compensation
For 2012, my lord. It was of 2012. Amended subsequently.
to the victim as per the procedure prescribed in section 357A CRPC. It is. Yes.
One item, item number 1, 2, and 3, my lord.
Yes,
And 4, my lord. Actually, I'm appearing for item number 2, my lord. Item number 1, Mr.
P. Datta, my lord. He has got prostituted because of storm. He cannot, he has informed me that he is unavailable.
Ramel.
So I will pay that.
He is affected.
He is affected, my lord.
Okay, what to do?
It may be 6, my
Item
lord.
1 to 4. Where is the council? Respondent.
Respondent CBI counsel is there. I will inform him.
He is there.
Good. Yes, sir. Oh. Because Siddhartha Burga is appearing on item number 4. He also doesn't, he has some personal difficulties.
Okay, you keep somebody here at 2. That counsel for CBI.
He was there, Lordship. He was there, Manas Hala was there.
Ah, yes. Maybe because it is beyond 2.
Yes,
Left
yes.
or beyond 1.
Stipul-
Will resume at 2.
Yes.
Somebody mentioned Mr. Kotoki. MS Bhuya, what to do? Yes. Nobody has stand up.
Mr. Manas Hala was there. My heart doesn't this one, no? Tomorrow, 1 to 4. What is that?
Is Kotoki available?
He's not,
Mr. Kotoki,
that's why he asked for adjournment, my lordship.
what is his instruction?
In instruction, other side is APR, so pass over the matter for Gadi.
He appears for who, which one?
Item number 2,
Item
Jamaluddin.
number 2,
Jamaluddin.
Zaman. Kotoki. Who is in 1?
One, as per my instruction, due to rain,
Oh,
advocate
somebody.
Pranjal.
P. Dotto.
Yes. Mhm.
Yes, Mr. Haloy,
Lordship.
before break.
Highly
Mr.
up to your
Kotoki.
lordship. Yes, yes. Highly up to your
And
lordship.
he also informed that Mr. P. Dotto in item number 1, he is facing some difficulty because of the inclement weather. He has,
Problem.
something has been damaged.
Leave up to this honorable court to decide. Lordship.
And what is the instruction of Mr. Kotoki? When he wants.
As for the day, yes, you.
Then let it be in the month of June, Lordship.
June, any date, my lordship.
On 10th of June or possible. Then. If hearing day is required, then 11th of June, Lordship.
It is not given. 2020,
20.
20.
20 June.
Yes. Okay.
History, 18 something has been fixed already. 20.
Highly.
Okay, Mr. P. Kotoki. Learned counsel for the appellant in 2. And who are the others? In
I think
3,
Mr. Buraguha is appearing in Rupdhan Chakma.
nobody is there. Okay. Has submitted that Mr. P. Dotto, learned counsel for the appellant in 1. Is not in a position, has not been able to come to the court due to the inclement weather. First of, as all the appeals are from a common judgment. Common judgment.
Common judgment.
From a common judgment and order from Mr. Kotoki has submitted that the appeals be taken up on after 2 weeks post of Mr. M. Halloy Larnett, Retainer Counsel for the respondent CBI is present post of in view of the request made by Mr. Kotoki. And as agreed to by Mr. Halloy Larnett, Retainer Counsel CBI, released these appeals on 20/06/2000.
Halif,
He was there, Mr. B.N.
Dr. Gogoi. Let us have a look.
I know. It was an 8 was 9 to the
Ratna Bahadur. Arjun Rai, my father. Father. He committed murder with Lathi.
police.
313.
Yeah.
Admission.
Oh, sure.
3:30.
The paper book.
You don't have to have a. 313 I told people police
Yeah,
that
nine-
I
nine
also
to-
checked the accused. Arjun Rai, as he was telling me that he would die, and consequently the accused had died. And page 22. Yes, I told that I killed the victim as my head was not working. Es cierto, digo, para los autos.
Nine police?
Extrajudicial confessions and by PW2 होता है. He has killed with a bamboo stick. Post occurrence sequence. I was at home, so I transferred. Yes, nine. I asked the accused why he had killed. Gupta, PW2, PW3.
No. Final hearing. Yes.
Wide perimeter left hemisphere. Respiratory distress, type of weapon plant. Injuries externally in hard substance. The structure of temporal bone. Extracting membrane inside his picture.
He has admitted his guilt in 213.
It appears no witness otherwise. Extrajudicial confession. PW2 and PW3. That's medical evidence. Extrajudicial confession. Medical. Net amicus curiae. For the appellant. Is found absent today on call. You need paper book.
Lordship, maybe given Lordship, they came across an order dated 21/7/2019. Examination of mental condition of the accused Ratna Bahadur Chetri is in the LCR.
Ah.
Date is given and not. Lordship, cognitive function, a report has been given by Superintendent District Jail Tinsukia. Speech relevant and coherent, decreased rate and flow of speech, delayed reaction time. Mood and affect says feeling comfortable, affect blunted, mood incongruent. Thought, no formal thought disorder, depressive content present. Perception, no perceptual disorder. Cognitive function, consciousness and orientation, conscious and well-oriented to time, place, and person. Attention, concentration, aroused but ill-sustained. Memory intact, intelligence average, abstract thinking normal, judgment intact, insight true, emotional insight. Oh, the said patient is known case of schizophrenia. As per the discharge report from AMC, Lordship, mein kar liya bolu.
But on the relevant date, what is that?
Whether he was suffering from.
There is no plea whether he was represented by legal counsel or state counsel.
Legal aid counsel.
Legal counsel. Legal one. In 2019, judgment.
31/7/19.
31/7.
Nara, 2.0 apna ka?
Known case of seizure patient.
Wait to get it.
It was within the additional public prosecutor. Assam has submitted it. A copy of the paper book be furnished. As we will record because you have received earlier. You have received a copy of the paper book earlier. So,
Personal receipt,
no,
maybe by office minor.
signatures are there. I don't know whose signature.
M. Sharma, then office is received it.
Find out then. Whose signature? Otherwise, you can order.
Minor. Yeah, minor, okay.
As the earlier paper book.
Office
Received,
of the public prosecutor, your lordship.
earlier paper book received by the public, received at the office of the public prosecutor. Is not received. Post of office to furnish.
Personally,
Ah,
again, they'll
office
get
to
this.
furnish a copy of the paper book to MS Mia. Learned so and so within a period of 7 days from today. Release the appeal in view of non-representation on behalf of the learned amicus curiae. for the appeal. Release the appeal after a week. On a date to be fixed by the office.
Insanity.
Item 9,
এইটো তো any stage ল'ব পাৰে কিন্তু document-টো আপুনি
You have the
Here
paper?
supplementary paper book has been furnished.
You have received.
Address is
Mr.
absent.
Dr. B.M. Lewis. Planet amicus curiae, I go to the kitchen. He is found absent today on call. Yes. B. Bhuyan. He is present in view of non-representation. In view of absence of Dr. Gogoi Laden amicus curiae for the appeal. Let the case be, let the appeal be listed after which on a date to be fixed by the office.
item number 11. May please your lordship.
What is the controversy about the identification?
That is settled, my lord. There was a report on the last occasion when it was furnished.
In house or?
Lordship, if this, can this matter be taken up on some other day?
Okay.
Any other day?
Any other? After a week then,
My lord.
after a week,
Well, later date may be fixed, my lord. It doesn't come
will
up.
not
You can-
fix date,
You can have to make a mention, my lord. It doesn't come up.
2022 appeal only.
20. 2 years we have been.
2 years. We don't give priority to 2 years. We give priority to 5 years and more. 1 week. Heard Mr. P.K. Munir, Mr. P.K. Munir, learned counsel for the appellant number 1 and 2.
1 and 2.
And Mr. D. Bora, learned counsel for the appellant number 3 and 4 are present. Okay. MS B. Bhuyan. On the request of MS B. Bhuyan. Counsel and additional public prosecutor. For the respondent state of Assam. As requested, lays the appeal after a week on a date to be fixed by the office.
After.
Item number 12.
For my note in the morning, return home. Yes,
Let's see, let's start, let's see, or.
yes.
Let's see. Let's see.
Huh?
Let's see, I'm ready.
Okay.
The meter is otherwise small meter, let's see.
Ready? Okay, let us read the FIR.
Let's see, it is at page 4, let's see.
Yes, here, 41. Yes.
lost by the mother.
Yes, Mr. Devchuri. We don't think my brother as well as me. I don't think your cases will be complete.
No,
Right
it
now.
will not be completed. Let it be in the, any other day convenient to your lordship.
Agreed, later. It is regarding what? 21A4? 21-4 or against final judgment?
No, 21. I guess bail, rejection.
Section 21-4. Get an agreed date from the court master, we'll pass that accordingly. Yes, Mr. N.K. Kulta.
Item 13, I was there.
Case of acquittal.
Am I Kashmir?
Case of acquittal.
No, Malay, no. I don't think so, but it may be a Malay part. Circumstantial evidence, Malay.
Okay, next week. Next week. Let it be left over.
Malay.
One additional affidavit. But in the assessment order, if your lordship may kindly see at WPC 6864/2022.
Page.
So
which
it starts
file?
from 154, part of the petition, annex 18,
154.
154. This is an assessment order under section 42 of the VAT Act 2003. Lordship will kindly turn to the next page, 155. Para 3, completion of audit assessment. The audit assessment of the dealer for the year 2006 and 7 was done by the Deputy Commissioner of Taxes, Tinsukia Zone on 10/3/2012. My lord, so far as this my lord order is concerned, there are various similar orders in various assessment years. For this particular case, lordship will see my lord, the assessment year is of 2006 and 7.
Yes.
The petitioner submitted my lord the application for refund. It is a page my lord 56 on 26/4/2010 for this particular financial year. 26/4/2010. Page 56. For refund. And my lord, on 10/3/2012, the audit assessment was made, but considering the my lord, this refund application. And it has been rejected, but that assessment order is not part of the report. Our contention in the affidavit is that, my lord, as well as in the impugn speaking order, is that, my lord, without challenging that assessment order, they cannot now come up and say that you are entitled for refund, because it has been rejected and they never challenge it. That assessment order we want to bring it to report. In fact, the Advocate General, my lord, after going through this entire report, he was waiting, my lord, but some difficulty by 3 he had to leave. So he has, my lord, prayed, my lord, that some, my lord, time may be given so that that assessment order can be brought into record. This will be vital for this particular case. Because, my lord, from page 154, there are various assessment year orders, and it continues till page 193. Every assessment year, my lord, there was already an assessment order which was passed earlier, rejecting the claim for refund, and which has not been put to challenge. Well, that will bring into record.
Because if I remember correctly, we went through all the decisions of the
Yes,
Supreme Court
Yes,
in
yes,
the
sir.
hearing so far.
yes,
We have not gone into the factual part.
Yes.
I think if I remember correctly,
You know, my
whether
lord,
coke
factual part, my
includes,
lord, their contention is that, my
whether
lord,
coke includes petroleum coke or not, on that
yes,
aspect,
yes.
we have
Whether,
had,
my
because
lord, now,
from, I think 1970s, that debate
yes,
was going
Bihar,
on,
state of
right?
Bihar, yes, yes, my lord.
If I remember
Yes,
correctly.
No, their simple case is that, my lord, since now the Supreme Court has settled the issue, you will have to refund it. Our case is that, my lord, simply making that particular demand will not do. You have submitted a application for refund, which was rejected by a audit assessment way back in 2012 and thereafter in various assessment years. And without challenging that assessment, my lord, order,
Or
I pray, my lord, that we'll grant some time so that we can bring it to record. That's all.
how much time?
I pray, my lord, on 20th of June, my lord. That's a Thursday.
We also don't know whether we will be sitting, because
Lordship will tentative, my lord, will fix
we
it.
can
on 20th.
give after 2 weeks or 3 weeks. We don't know because it is very difficult to allocate. I don't know I'll be sitting where.
My lord. Then, my lord, Lordship will proceed after 2 weeks. I will make a mention, my lord, of considering, my lord, a discussion with the
Okay.
other side.
If you want 20, then it will be to about 3 weeks. Mr.
PK Warlord.
Vora. Learned Council Court of Petitions is present.
Is going to be-
Mr. B. Gugoi, Learned Standing Counsel. Finance and Taxation Department has prayed for listing of the cases after 3 weeks. As there appears in necessity to file additional pleadings on factual aspect. Post up. As prayed for by Mr. Gogoi. Learned Standing Counsel, Finance and Taxation Department.
will
On
mention
behalf of
further
the
hearing.
respondents.
Further hearing on, further hearing on after 3 weeks.
No, I think it is,
In the court list, it has not been shown as part heard, but further.
no, it
hearing-
is
Yes,
in related
yes,
marked to this court.
yes, yes.
So, and
Then, my lord,
Yes.
on a convenient, then, my lord,
as,
I will make a mention.
as,
my lord.
as,
Over.
and the said prayer is not opposed by the Learned Counsel for the petition. Comma, lists the cases after 3 weeks on a date to be fixed by the registry.
Well. And my lord, item 2 to 5, my lord, they are yet to, my lord, place the, even the facts before this honorable court. It is slightly different, so.
Okay, okay.
we'll fix it. You are dealing with one only.
No, I am only aware of the
That's where is the-
petroleum or petroleum coke.
Yes. That is a subtle issue.
Only that issue was addressed
Yes.
and that is settled otherwise.